Is the Voting Rights Act being dismantled from the inside out while the public looks the other way? Justice Ketanji Brown Jackson just sounded a massive alarm, and her latest dissent might be the most chilling warning yet for the future of American elections. We are witnessing a fundamental shift in how power is distributed in this country, and the highest court in the land is at the very center of the storm. Before we continue, if you want to stay on top of everything happening in U.S. politics and understand the deep legal moves that the mainstream media often overlooks, hit that subscribe button right now and leave a like. It really helps this channel grow and ensures we can keep bringing you these deep dive reports. The Supreme Court has once again thrust itself into the center of a heated redistricting war that could determine the balance of power in Washington for years to come. On Monday, the court issued an order that might seem like a technicality to an outsider, but to legal experts and voting rights advocates, it felt like a seismic shift. The justices sent a high-stakes Mississippi case back down to the U.S. District Court for further consideration. On its surface, that sounds like standard procedure. But the catch is that they instructed the lower court to reconsider the case in light of their recent, controversial ruling in Louisiana versus Calais. This move immediately triggered a sharpened public protest from Justice Ketanji Brown Jackson. To understand why she is so concerned, we have to look at what happened in Louisiana. Just last month, the Supreme Court limited the scope of Section 2 of the Voting Rights Act. That specific section is the crown jewel of the civil rights era. It's the tool used to prevent states from drawing district lines that dilute the political power of minority voters. In the Louisiana case, the court essentially sided with those who argued that the state didn't necessarily have to create a second majority black district, overturning a lower court's attempt to protect minority representation. Now, the Supreme Court is using that Louisiana precedent to reach into Mississippi. But here's where Justice Jackson says the court is making a dangerous mistake. She pointed out that the Mississippi case is fundamentally about something else entirely, Section 2's private enforceability. This is a fancy legal term that asks a simple but devastating question: do individual citizens and civil rights groups actually have the right to sue under the Voting Rights Act, or can only the U.S. Attorney General bring those cases? If the courts eventually decide there is no private right of action, it would effectively kill the Voting Rights Act. Why? Because the Department of Justice doesn't have the resources and sometimes doesn't have the political will to challenge every unfair map in every state. Most of the progress made in voting rights over the last 50 years has come from private citizens and groups like the NAACP taking states to court. Jackson is arguing that the Louisiana ruling didn't even address this private enforceability issue, so using it to vacate the Mississippi judgment makes no legal sense. In her own words, "I see no basis for vacating the lower court's judgment." This isn't just a disagreement between judges, it's a battle over the redistricting war being waged between Republicans and Democrats. For decades, the Voting Rights Act allowed plaintiffs to challenge maps by showing that they had a discriminatory effect, meaning, if a map resulted in minority voters being squeezed out of power, it could be struck down. But the Supreme Court's recent trajectory, including the Louisiana case, is shifting the goalposts. Now, it is becoming increasingly necessary for plaintiffs to prove a discriminatory motive. Think about how high that bar is. You don't just have to show the map is unfair, you have to prove that the lawmakers who drew it were intentionally trying to discriminate based on race. In a world where politicians have become very good at hiding their intentions behind partisan excuses, proving motive is almost impossible. This shift gives a massive advantage to state legislatures, many of which are currently controlled by Republicans who want to draw maps that favor their own party while potentially diluting the influence of Black and Latino voters. The implications for the 2024 election and beyond are massive. We are talking about the potential wiping out of hard-won legal victories that ensured fair representation. If the lower courts follow the Supreme Court's instruction and apply the Louisiana logic to Mississippi and other states, we could see dozens of congressional seats shift. This could create a permanent wall that prevents minority communities from electing their candidates of choice, all under the guise of clarifying the law. Justice Jackson's protest highlights a growing frustration among the court's liberal wing. They see a majority that is increasingly willing to use shadow docket orders and technical remands to reshape American democracy without the scrutiny of a full trial or oral arguments. By sending these cases back down with specific instructions to follow a more restrictive precedent, the Supreme Court is effectively steering the ship of American elections toward a much more restrictive future. Who is affected by this? Ultimately, every voter is. When the rules for how districts are drawn become more opaque and harder to challenge, the accountability of our elected officials drops. If a politician knows their district has been safely drawn to exclude certain voices, they have less incentive to listen to those voices. This is exactly what Justice Jackson is warning us about: a legal environment where the protections of the Voting Rights Act exist on paper but are impossible to trigger in a real courtroom. So what do you think about this? Is the Supreme Court right to narrow the scope of the Voting Rights Act to prevent what they call race-based gerrymandering, or is Justice Jackson right that they are systematically dismantling the protections that keep our elections fair? Drop your opinion in the comments below. I read every single one and I want to know where you stand on this legal battle. The fight over the Mississippi and Louisiana maps is far from over, but the signal from the Supreme Court is loud and clear. They are moving toward a more restricted interpretation of federal oversight in state elections. As we head into a pivotal election year, the maps we use will determine the voices that get heard in the halls of power. We will be watching the lower courts closely to see how they handle these new instructions from the High Court. Stay tuned to this channel as we continue to track every major development in this high-stakes battle for the American vote.